That crew, listen up. I know firsthand how limited a vessel medical insurance can be. This is why you need reliable medical coverage. Moore Dixon offers comprehensive global insurance tailored for yachties, covering everything from emergencies to routine checkups with flexible options and a single point of contact. Moore Dixon has been voted best health and medical insurance by captains and crew, including myself. Don't wait until the unexpected happens. Get covered today. Visit mdbl.im or email them at inquiries@mdbl.im for a free quote. Hi, everyone, and welcome to Uncensored. I'm your host, Maritime from Yachts, Mermaids, and today we're diving into episode 3, the final one of a powerful 3-part conversation with maritime attorney Adria Notari. Adria is a former captain and former U.S. Navy Reserve lieutenant, bringing a rare and an invaluable combination of seafaring experience and legal expertise to this conversation. In this episode, we cover civil versus criminal law, building a case with the right evidence, statute of limitations, who's responsible for crew safety, and why litigation drives real change in the industry. If you missed part 1 and 2, don't forget to watch them as they cover your basic rights at sea, contracts, and what to do when reporting abuse is not taken seriously on board. The link is in the description. Let's dive in. When it comes to bullying, when it comes to harassment, when does it become criminal harassment? Because what I understand and what I have heard is that a lot of the time, these are not crimes. So I guess you cannot litigate, you cannot go to court because of it. So when does it become something that you can then potentially do something about it?
Okay, yeah, so this is a very hot topic and also a complicated issue. I'm not a criminal attorney, so I'm not going to give criminal advice, and and every country is different on whatever their criminal laws and their criminal statutes identify as being a crime or not being a crime. But just because you don't criminally prosecute a crime doesn't mean that you don't have a civil remedy. So you can be in a situation where, unfortunately, you're a victim of assault and you contact law enforcement, you contact the police, and the police say, well, you don't have a case. We're not going to do anything. Sorry, we can't help you. Get out of here. Have a nice life. That's discouraging that they're not going to take any criminal action against the assailant, but it doesn't mean that you don't have a cause of action for civil assault. And so those are the cases that I handle. I don't handle criminal cases. In the United States, it would be the state that pursues criminal action against an individual. And then what happens is the state tries to put that person in jail and, serve prison time for the crime that they committed after they prove all the elements beyond a reasonable doubt. I don't do that. I don't work for the government. I'm not looking to arrest people. So my job is, as a civil attorney, I help these victims and survivors and these champions for change. I help them get civil remedy, civil causes of action against the assailant. And if it happens in the workplace, because I'm a seafarer attorney, then I go after the company or the employer. That's why the employer is so important. I go after the employer because if the situation was such that the environment was ripe, that this was going to happen, and the company knows about this problem, and the company doesn't do anything about it, and the company sweeps it under the rug, and the company covers it up, then we can go after the company and say, look, the company knew that this was a problem, or they should have known. If they were taking reasonable care to guarantee this reasonably safe workplace, they wouldn't have allowed this to happen. And so then that assault victim, the injured party, has a civil case against the employer. as well as the assaulter, or the assailant, or whatever you want to call them. So,
and can you have both, like civil and crime litigation at the same time?
Absolutely, absolutely, you can. But remember, the criminal litigation, it's not. So, in my civil practice, I practice civil law. Maritime law is civil law, and I represent crew members. So, in our situation, the case will be, my crew member versus the employer or the vessel or the company or whatever the case may be. So it's, Jane Smith versus ABC company and the assailant. In a criminal matter, it's going to be like the state of Florida versus the person who committed the crime, not against the vessel, not against the employer, and the goal is different. So the goal of the criminal matter is to put that person in jail, so that person doesn't continue to commit those, assaults or trafficking or, whatever the case may be. I don't do that in my practice. I don't work for the government, so I'm not prosecuting crimes. I'm a private civil lawyer, and I represent crew members who have been injured or assaulted, or they haven't been paid, or whatever. They have an issue with their employer, or they have an issue with the vessel, or they have an issue with the company. And then I represent, the case will be that injured person's name versus either the employer or the vessel or both.
That makes so much sense. And thank you for clarifying that, because
Sure.
it seems so obvious now that you say it. But yeah, we get very clouded because we don't know anything about law. And, especially when you're a victim or something happened to you, you're not thinking straight. You're like completely traumatized. So it's hard to kind of know what to do and where to go, So I think this is why, doing podcasts like this with people like you, experts like you, is so important, because this educates people and gives them the tools before something happens, so they know what to do when something something does happen that hopefully doesn't happen. Okay, so that clarifies that. So let me see, what was the other thing I wanted to ask you? Okay, so we're gonna move into, let's say you did the reporting, and again, DPA fell, captain, flag state, management, nobody's doing anything, which is what we see often happen. What are the legal steps that the seafarer need to take in order to be able to escalate the case to potentially litigation or just getting the result that they want?
I would say that if a crew member is in a situation like that, where they've contacted all the people in the chain of command, the DPA, the flag state, and they're getting these doors slammed in their face, they need to contact an attorney. And that, the crew member doesn't have to be an attorney. I think that's the big theme of our conversation today, is that crew members are bombarded with all these acronyms: ITF, ILO, MLC, IMO. None of that, the crew member doesn't have to be an expert at maritime law. The crew member doesn't have to know, well, what should I do now to escalate the case? That's an attorney's job. Contact an attorney.
But do we have to have something ready so that when we do contact, the attorney can say, hey, you know what, we can help you, we can have a case? Because maybe I'm just wanting to know, as a seafarer, is there something you have to have prior to contacting an attorney to potentially the attorney say, yes, we can help you, there's a possible case here? Or no, you don't have any evidence, you're missing all this stuff, sorry, great story, but we cannot do anything for you?
Well, that's interesting, because in this hypothetical that we're discussing now, if there's a situation like that where the crew member has contacted DPA, port state, the management company, and gotten these doors slammed everywhere, that's evidence. Hopefully there is an email that the crew member sent an email and they got no response. The crew member reported it to, the legal authorities, the police, law enforcement, and they got no response. So all of those unanswered emails are evidence. It's evidence that that the incident was reported. It's also evidence that helps the attorney form a timeline. Like, look at this. The assault, the first time that this uncomfortable situation of harassment or whatever occurred was on such and such a date. The crew member did the right thing. He or she informed the supervisor or, whatever. It shows that all of these steps were taken and then they got no response. So all of those things that you're saying are evidence. It is evidence that the crew member did take active steps to do what should have been done, but either the company doesn't have any procedures in place or the company doesn't care and the company wants to send them an NDA or shut them up or pretend like it didn't happen or retaliate or fire them. Or all of those things, they are evidence, So that's, for that specific scenario, I would say that. Also, many times in injury cases, not all cases are sexual assault and sexual harassment. In an injury case, let's say you're working on a yacht and, I got injured with a hatch that goes from the main deck to the engine room. I would recommend that if you're in a situation like that, take a picture of that hatch. That's evidence. Take a picture of your work area. That's evidence. Take a picture if, you were working for months and years in these cramped spaces. Take a picture of those cramped spaces. That's a very helpful tool. That's evidence. And that's directly on board, because then afterwards, when you hire an attorney and the vessel is like in a different part of the world, it's going to be very hard for me or any attorney to get on board and capture those pictures. So if you can get that while you're on board, that's already like a huge head start to help you, build your case, if you will. But I don't think crew members should be worried about, how am I going to build my case? That's the attorney's job.
Thanks for reminding us of that. So, can legal action still be taken after a seafarer disembarks or leaves the country where the incident happened? Are there any statutes of limitations where, this amount of time passes, well, you can't do anything about it?
Yes, well, those are two different questions. Can the seafarer still have a claim after he or she leaves the vessel? Absolutely. Absolutely. Under, again, because I'm an attorney here in the US, so under US law, the statute of limitations is 3 years from the time of the incident.
Okay. But
that's the general rule for general maritime claims. There are some claims like sex trafficking. Sex trafficking has a 10-year statute of limitations, but sex trafficking is not uniquely maritime. We see a lot of sex trafficking in the maritime industry, but it extends to other industries as well. So that's a different statute of limitations. But I would say in general, if you have a workplace injury or incident that happened while you were employed as a seafarer on the vessel, under US law, the statute of limitations right now is 3 years for crew members. For passengers, it depends. Are you a passenger on a cruise ship or are you a passenger on a different vessel? Because in those situations, it's not the employment agreement that guides us. It's the ticket. If you have a written ticket, like if you're on a ferry or a cruise ship, there might be a limitations period that's identified, like on the back of that ticket, on the small print that nobody sees, but that's what's going to govern the limitations period in those cases.
Okay. And if the evidence, for example, if the report that was submitted was anonymous, can that be used? Or it has to say your name, and everything?
No, it doesn't have to be. You don't have to identify yourself in a report. Even an anonymous report, it can still be used as evidence. There are situations where a crew member is afraid to identify themselves. So that's perfectly understandable. And they'll submit a report anonymously, maybe to HR or the management company. If and when litigation ensues, then that person who submitted the anonymous report can testify about that. They can identify themselves later.
Sorry. And how long does it usually take to build a solid case for litigation?
Oh, well, for injury cases, the longest time building the case, as you said, is while the crew member is receiving the medical treatment that they need so that they can recover. So that's the first thing. If someone has a disabling injury that maybe needs surgery and physical therapy and all of those things, that medical treatment takes time, and the medical treatment is the priority. So we don't want to rush a case while the crew member is getting the medical care that they need. And by the way, it shouldn't be at their own expense. The employer should be paying for the medical care. So while that's going on, the case is, you're building the case, because these medical records are part of the evidence building the case. So that could take long depending on how complicated the injury is. You also have to build a case with, evidence, testimony, investigations. So there's no set guideline for how long it takes to build a case. It could be a matter of months. It could be a matter of years. There have been situations where crew members are litigating for like 5 years and still building the case, so to speak. So yeah, it depends on how serious the injury or the damage is to the injured person. And then also identifying all the responsible parties.
And going back a little bit to flag states, you have these organizations that are creating these guidelines that are basically saying to the flag states, hey, these are the guidelines that your vessel should be following. They're the ones that are meant to be holding accountable the vessels to follow those guidelines. Vessel meaning the employer, right, of the vessel, because the employer is the person or the company that is in charge of creating the safety and following these guidelines. But the flag state is meant to hold these companies accountable to following these guidelines on board. So if they're not being followed, can a crew member go not only after the employer, but also the flag state? Is that something that can be done? Because to be honest, I feel like flag states they are a big issue. They are part of the problem. They're making money, they're making, all these registrations for the vessels, but they're not holding the employer accountable for the safety of the crew members and the vessel, whether that be, environment or psychological or physical or, human rights. They're just not. So can they be held accountable in the law, or we just go after the employer and not the flag state?
Well, right now, there's no clear path to go after a flag state when something bad happens on a vessel. Because flag states are, governments of different countries and maritime administrations of different companies. So sometimes they're shielded because they're governmental entities. But what I've seen in my practice is the best way to bring these issues to light is litigation, and then legislation. So we also push for legislation on different things. And if there are a lot of, let's say there's a lot of litigation about vessels flagged in a particular flag state that's really not being responsible, not being mindful of crew safety. If enough of that litigation gets filed, that raises an alert for the IMO to say, well, maybe we don't want to authorize that country to be able to flag vessels anymore because they've abused that privilege. It's a privilege. We're seeing now even landlocked countries have flag states to register ships and yachts and boats. So these particular countries have no coastline, but they have a flag registry because, as you said, it's a money-making venture. But you've got to have compliance with IMO and SOLAS. So in my mind, when enough of these situations arise and you can say like, oh, this is another case where the vessel was flagged in this particular country. This is a problematic country. This country is not complying with the protocols and the guidelines and the seafarer safety and human rights, and they're just abusing this privilege. Well, we're not going to let them have that privilege anymore of registering vessels.
Yeah. I mean, in my own experience and from what I hear day to day, this is a big issue. Flag states, they're just not doing what they're meant to be doing, which is ensuring that the employer that is registered under their flag, it's following protocol and guidelines, and then we have all these issues, and then you reach out to them and then they're like, oh, well, we're flag state, we can't do anything about it. I'm like, then what's the whole point of flying your flag? What's the whole point of having you as a registration, apart from maybe like tax haven, for the shell company role, So talking about, all these issues, the MLC says, the guideline says, again, blacklisting crew is illegal or it shouldn't be done. But how can crew members challenge this practice when it involves maintaining database of alleged problematic crew or non-abusers? Because it's like there's like this, like, oh, you can't blacklist people, but how do we maintain the perpetrators known, and potentially out of the industry?
Well, you can't blacklist people for, as I said earlier, like filing an injury claim or pointing out some safety issue on the vessel. But to blacklist someone who is, abusive or a sexual harasser or sexual assaulter, like that's a different issue, because there's no, the balance in that situation should be to protect other future victims from this person who we know to be an assaulter. So that's a different situation. Typically, what we're saying about like retaliation law and blacklisting is about a crew member who's hasn't done anything wrong, but for example, the crew member has pointed out to the authorities that this vessel has, I don't know, a dangerous feature, or they have a safety violation, or they have something that's creating a dangerous situation for the crew, and they report that to flag state. So that crew member is doing a good thing, and the law wants to protect people like that from speaking out. Hey, there's a safety violation here. I'm going to raise my hand and I'm going to point it out so that somebody can do something about it, so that people don't get hurt. So the law protects that person from being blacklisted. But there's no law to protect rapists and assaulters and assailants. There's no such policy. So in that situation, unfortunately, we see a lot of repeat offenders get rehired, and that's a problem. So that's being distorted. Retaliation laws were created to protect people that were doing an overwhelming good, like for doing good for other people. Like the situation that I mentioned, like, someone pointing out a safety violation on a vessel. That person is doing a good thing. That person is doing a courageous thing, because that person doesn't want to see other crew members get hurt with this safety violation. So the law protects that person. Otherwise, those people won't be encouraged to speak out. They'll be afraid of losing their job. But there's no need to protect people who assault and harass and bully and rape people on yachts. There's
even if they haven't been, what's the word in the legal term? Like they haven't been, it's like allegedly, right? Because there's no case built on them, because maybe nobody has spoken about. Because in the industry, in the yachting industry, and I think all in the maritime industry overall, but I can only talk about the sector that I'm part of, we see that we all know who the perpetrator is, but nobody has gone the legal route against that perpetrator. So it's still allegedly, because they haven't been, I don't know what the word I'm trying to use.
Adjudicated? They haven't been adjudicated.
So would that still be blacklisting somebody wrongly or no? Like, do they have to be adjudicated, or can we still blacklist them?
Well, there can be situations where the person hasn't been adjudicated, there hasn't been like a criminal conviction against that person, but the company has done an investigation and said, oh, based on our investigation, my goodness, this person he's extremely inappropriate, he's sexually violent in the workplace, and we just can't have it. That's not blacklisting, that's ensuring the safety of the vessel by not rehiring this person who, as a result of, maybe the person hasn't been adjudicated, but as a result of the company's own internal investigation, my goodness, this is a repeat offender, or this is a person with violent propensities. It's not the first time he assaults someone. It's not the first time he attacks. There can be internal investigation that doesn't lead to a criminal conviction or an adjudication, but it's enough of an indicator that, like, we don't want to hire this person again because he or she is dangerous on board.
Yeah, absolutely. So, I mean, I can talk with you forever. There's so much to go around, but we're going to bring this episode to an end. I hope that this is the first. I hope it's not the last. And I want to close it with, what practical advice would you give seafarers to protect themselves legally and professionally before joining a vessel?
Before joining a vessel? Well, I think you want to do research, and I sound like a broken record here. Who is the employer? Who is the employer? Because the employer is the one that has all these responsibilities that are going to affect my rights as a seafarer. So who is my employer? That's the first thing. And, it depends on the vessel. If you're working for a more sophisticated organization that has the employment contracts and multiple vessels and their head office and their headquarters, then it's more organized. So there's less of a burden, less of a hazard, I would say, to crew members in that initial job contract. But if you're working on a smaller vessel, you absolutely need to know who the employer is, because if something bad happens, you have no remedy if you don't know who your employer is. And you also need to try to find out, like, if the vessel has insurance. Does the vessel have an insurance policy? And who's the insurance carrier? Because can you imagine a situation where something happens and there is no marine insurance to cover the situation, your medical bills or your expenses or whatever the case may be? So you want to try to identify kind of like things that we hope don't happen, but unfortunately, they do happen. It's a reality of life. So working on a yacht can be a very awesome, exciting experience, but in the back of your mind, like, suppose something does happen, what are my remedies? What's my protection as a crew member? So who's my employer, and try to find out, like, what the vessel has as marine insurance. Absolutely.
Yeah. And I'm going to add to that, asking those hard questions that are not really hard is just to protect ourselves. What are the policies in case of harassment, bullying, assault on board? Like, asking those questions before you join a vessel are going to let you know if this is the right vessel to join, if they're there to support you and protect you, or if they could potentially be the perpetrator themselves. I think these are the questions that people don't ask until something unexpected happens. And then by that time, it's a bit too late because it already happened. So I think we need to all, as individuals, take responsibility for our own lives and our environment and the work environment in this case, and just really ask the right questions. And like you said, educate and do your research, know where you're going to work. Because like you said, it could be very exciting, and it is. But when things go bad, they go bad really bad and very quickly. And then, it's a matter of then going the legal route most of the time. So how can people work with you? How can people contact you if they have questions, if they want your support?
I'm on LinkedIn. I'm a big fan of LinkedIn. I think that's how I met you, actually. So big fan of LinkedIn. The name of my law firm is Notari Law. And so the website is notarilaw.com. My name is Adria Notari. So it's a unique name. There aren't a lot of Adria Notaris that I know, so I'm pretty easy to find on Google or on LinkedIn as well.
And all the links are down below the video, so you guys can just click away and follow her on LinkedIn. And obviously, if you need support, then reach out to Adria. Thank you so much. This has been an eye-opener for me, and I have done a lot of research throughout the years. So if this helped me, I'm sure it's going to help a lot of people out there to get clarity around, maritime law and our legal rights and what we can do about it. Because like you mentioned, we can do something about it. And it is not up to the seafarer to understand the law. That's why we have lawyers.
That's great. That's exactly what we want to hear. No, information is power. So thank you so much for having me.
Thank you for listening. I hope this series gives you the clarity to know your rights, the courage to speak up, and the power to protect yourself and others. Keep learning, seek support when needed, and remember, real change starts with accountability. If you need legal advice, check out Adria Notari via the links below. And if this helped you, please share it with your crew and others. Until next time, keep learning, keep speaking up, and stay uncensored.
If your brand belongs in the heart of the yachting world, this is where it happens. Yachting International Radio reaches over 1 million yachting professionals and enthusiasts every month, with 77 million impressions, 220,000 social followers, and 74,000 podcast subscribers. Our hosts are insiders, crew, captains, CEOs, trusted voices shaping the industry. This is targeted, high-impact advertising in a luxury niche. Visit yachtinginternationalradio.com/advertise. Your audience is already listening.